Hi, in this latest immigration law update video, I'm going to continue my series on the new practice direction for the First-tier Tribunal, Immigration and Asylum Chamber. And in this video, I'm going to focus on country evidence in immigration and asylum appeals. So I've shared my screen, and on my screen, like in the other videos in this series, is the EIN link to the practice direction that's available to everybody, and I'll post it below this video. And as I've said in other videos, there's been a helpful guide published by the First-tier Tribunal, including a short video explainer, and the link to that is also set out below this video. But let's get back to the practice direction. Remember our key overriding themes to the practice direction. That's focusing on the disputed issues and conducting proceedings with procedural rigor. So procedural rigor and disputed issues. And in this video, as I said, I'm going to look at section 10 of the practice direction, and that's country information evidence. This will largely concern asylum or protection appeals, although country information evidence may be relevant in other cases. So don't switch off, because it may be relevant if you're arguing private life in terms of very significant obstacles to integration, or family life, say a partner case where you're arguing EX1B and the question of insurmountable obstacles. 10.1 sets out about reported decisions bearing the letters CG. So that's a country guidance decision. And a country guidance decision of the tribunal shall be treated as authoritative in terms of the country guidance issue identified in the decision based upon the evidence that was before the tribunal. And then it will be binding unless it's been superseded or replaced. 10.2 sets out that representatives should be familiar with the current list of country guidance decisions, because the failure to follow a country guidance decision 10.3 is likely to be an error of law. So if you're a representative, make sure you address the relevant country guidance decision. Make sure the tribunal's attention is drawn toward it, and also address it in your appeal skeleton argument. If you've got a country guidance decision against you, there's no point in just saying silent on it. You need to address it. And for example, if a judge did allow an appeal in ignorance of a country guidance case, it's going to be overturned in any event. So it's important to address country guidance decisions. 10.4 says this: only if there is no applicable and or relevant country guidance, or a party argues that the tribunal should depart from the country guidance, is it necessary for a party to provide background country material or information relating to the country background or conditions. 10.5, any party who wishes to rely on country background information which is not available in the relevant country guidance decision must make this clear and identify the disputed issue to which it relates. So it's worth setting out in your appeal skeleton argument in relation to that cross-referring to the country evidence and what disputed issue it relates to. But what you're to provide is not now, like in the past, hundreds of pages of country information, but a country information evidence schedule. So in your index to your bundle, one of the items will be the country schedule. So 10.6, parties relying on material within country guidance decisions or additional country background information must include a country information evidence schedule within the bundle. This schedule must contain the country guidance paragraph references and or the extracts of the additional country background information relied upon by reference to each disputed issue. So it's probably worth breaking your schedule up into headings. Say it's a protection claim. The disputed issues are risk and relocation. You have a heading of risk, and then your country paragraphs and extracts are set out below that, and then a heading for relocation where you set out your extracts for that. Remember, it mustn't exceed 12 pages, and do be aware of the minimum size of font is 12-point font, and the minimum spacing is 1.5 line spacing. Just be aware of that, but mustn't exceed 12 pages. But helpfully, you don't have to include the whole document. You just include the relevant hyperlink to the background information source document. It's only if a party challenges 10.7, the accuracy or the context of the extract, they can put the other party on notice within the ASA, or if it's the Home Office doing it in the review, that it'll be necessary for the party to produce the whole source document for the hearing. Now, that's sometimes relevant because you might think in a Home Office refusal letter, there's a extract that's cited, and this applies sometimes to the CPINs, where an extract cited, and you think, actually, if you look at the whole source document, or if you look at the context, this actually isn't correct. So you might want to challenge that. So do be aware of 10.7. 10.8 provides that you can apply in writing with reasons for permission to rely on a schedule that exceeds 12 pages, and you need to attach that schedule to your application. I've opened up this link on EIN, and this is part of the public EIN site. EIN also has a subscription site where you can create these schedules. And there's a notice here on how EIN has changed its functionality to enable you to produce these schedules that are fully compliant with the new practice direction. And I've put the link below this video. But if you're going to rely on country evidence, you need to make sure now you're producing a schedule, not just dumping in hundreds of pages, but producing that no more than 12-page schedule that complies with the practice direction and including the hyperlink. I hope that's helpful to you. Thank you.